Hi, I'm Derek Gage with the Gage Law Firm, and this is Gage on Mental Health and Law. And today we're going to be talking about the insanity defense. What is it and what isn't it? Where does it come from? How is it applied here in the States? How do you build an effective insanity defense? And ultimately, what are the consequences of that successful defense? But let's start with what the insanity defense is not. A lot of times, even us as attorneys and judges confuse competency with insanity. Competency to stand trial is talking about the here and now. Is the criminal defendant in a position to effectively assist his or her attorney in her defense? So we're talking about their constitutional right to be present, both physically and mentally, at trial, or if they decide to enter a guilty plea, that they are able to understand the rights that they have and that they are giving up in order to enter that plea. Competency is talking about right now. With insanity, we're talking about looking back in time to the time the alleged offense actually occurred. And we're looking towards the state of mind of the individual at that time in the past. So these two issues often get conflated, and it's important to keep them separated because not only is competency a constitutional concern, insanity is very state specific and is defined by statute and is not a constitutional protection. The other thing to consider is that mitigation does not equal an insanity defense. In other words, just because a criminal defendant is dealing with mental health challenges doesn't mean they can effectively employ an insanity defense, particularly because the insanity defense bar is so high. But that doesn't mean you can't utilize any work that that person has done on their mental health to lessen any potential punishment or even to put them in a position where they may not have a criminal conviction at all. In fact, mitigation is often a better outcome than a successful insanity defense. So, where does the insanity defense come from? And what is it specifically? In American courts, when we are talking about the components of a crime, we're talking about two Latin terms, the actus reus, or the bad act itself, and mens rea, which means guilty mind. And with the guilty mind, you could essentially call that a volitional decision to commit that bad act. And you have to have some concurrence between those two things in order to form a crime and to create something that's eligible for criminal punishment. With the insanity defense, we're essentially looking at the mens rea element of the criminal offense. We're going to, in almost every case, stipulate to the bad act, but we are trying to find some sort of relief from criminal liability when it comes to that guilty mind. And we look to the person's state of mind at the time they committed that bad act. Relieving somebody of criminal liability goes all the way back to Babylonian times. In fact, the Babylonian Talmud has a passage, and I'll update the language, that it essentially says it's wrong to knock against someone with mental illness. He who injures them is guilty, but if they injure others, they are not guilty. So the seeds of this relief from criminal liability for somebody who is dealing with acute mental health symptoms goes all the way back in history to Babylonian times. But more specifically for American jurisprudence, we look to English common law. And the seeds really were planted in the case of Daniel Macnaghten. Macnaghten was a wood turner out of Glasgow in Scotland, and he ultimately moved to London and was dealing with clear mental health issues along the line. His father and other friends noted some strange behavior he exhibited, fears of being spied upon or being persecuted by the Tories. And ultimately, in January of 1843, he put a bullet in the back of Edward Drummond, who was the secretary to then Prime Minister Sir Robert Peel. And during Macnaghten's trial, he essentially pled through his attorneys insanity, that he was not capable of distinguishing between right and wrong, or that he was under some sort of delusional compulsion. Ultimately, he was found at that trial to be not guilty by reason of insanity and was hospitalized for 21 years before he passed away. The House of Lords took up the case and ultimately helped to define what insanity meant moving forward. And they defined it as having a mental defect that ultimately led to the inability to distinguish between right or wrong. And that was basically the encapsulation of the insanity defense for decades after. And it was adopted here in most states as at least one basis for establishing a successful insanity defense. So, here in the States, does every state have the insanity defense? The answer is no, because the Supreme Court has already established that the insanity defense, in and of itself, is not so rooted in American jurisprudence that it is a necessity to have it on the books. And so, four states don't have the insanity defense. Those are Kansas, Utah, Idaho, and Montana. But what they do have in each of those states is some modified way to utilize potential mental health symptoms to avoid criminal liability. And it's typically by defeating some element of intent in the criminal statute that the person is being accused of committing. In the other states, they rely on some version of a test in order to establish a successful insanity defense. That's either using the McNaughton test, as we just discussed, that a person is wrestling with a mental illness and is unable to distinguish between right or wrong. In some cases, it's the irresistible impulse or delusional compulsion test, where the person was simply unable to control whatever action they had when they committed the bad act. Or delusional compulsion is a little bit of a riff off of that we have here in Georgia. There is also the Durham rule. As I mentioned, New Hampshire is the only state that uses that. And in that case, the mere fact that somebody has a mental illness and it is the cause of the commission of the crime relieves them of criminal liability, but only in that state. Here in Georgia, we have a mix of both the McNaughton test and delusional compulsion, which says if the person was operating under a delusion to the extent that it overmastered their will and the act would have been justified outside of the context of the delusion, typically meaning something like self-defense. If the person was under some sort of delusion that they had to protect themselves from being attacked by somebody else, and in response to that delusion, they attack that person, then they would potentially be able to utilize that prong under Georgia's NGRI structure. Now, in order to build an insanity defense, you have to have a forensic expert in almost every case. Now, you're going to be relying on circumstantial evidence to build the case, but using a forensic expert allows you to establish it with authority. Forensic psychiatrists and psychologists are those who both understand psychology, psychiatry, the nature of diagnoses and how they operate, with the intersection of criminal law. They're able to analyze those two things together. And specifically, they're looking toward what they call criminal responsibility at the time of the alleged act. So they're going to be collecting data back in time, even though in most cases they're going to be doing the evaluation months and months after the act was alleged to have been committed. So what are they going to be looking at? They'll be looking at diagnoses. They'll be looking at past hospitalizations, anything that establishes the person had a mental illness at the time they committed the offense. A lot of times, they've had it for a good period of time before they committed the offense. In other cases, it was a first break, and they never really established diagnoses until after they were arrested. But in any event, that's something that forensic experts are going to be collecting, those records. They're also going to be talking with witnesses and looking at the evidence that's provided to the defense attorney to get an idea of the state of mind of the person leading up to the offense and shortly after. And then they're going to be talking to the defendant themselves to get some idea from them what their state of mind was at the time. Those things together can ultimately build an insanity defense, but they're also going to be looking at those things that might defeat it, such as voluntary intoxication. If a person voluntarily used drugs and that ultimately was the cause of their state of mind that might otherwise relieve them of criminal liability, then they can't utilize the insanity defense. They are also going to be looking for things like any sign of mens rea, that they knew what they were doing, that they felt guilty, that they tried to hide evidence, that they ran from the scene. These are all potential things that can poke a big hole in a successful insanity defense, and your forensic expert is going to be looking for those things. So it's important for us as defense attorneys to start preserving that data early on in the case and not waiting until the end. We want to be able to have those records put together. If we note certain symptoms in our clients, we want to be able to somehow document those either in notes. I've even done it sometimes with video in order to just demonstrate what their state of mind was as close in time to the offense as we can. You're also trying to limit the amount of additional information that might come out. And that usually means having your client keep their mouth closed, because almost everything between them and their family on calls is going to be recorded. And even small things can provide a basis for poking holes in an otherwise successful insanity defense. So, what happens if insanity is successfully utilized? You don't just walk out of the courtroom as an acquittee by not guilty by reason of insanity. You ultimately, in every state that you use it for, go to the hospital right after trial, or right after the plea is accepted. And all of the sudden, the analysis goes from one of criminal, whether the person is guilty of the offenses for which they were charged. In that case, you are relieved of criminal liability. But instead, you are now looking at being analyzed under the civil lens for commitment, which here in Georgia is defined, and in most states, as an imminent threat of substantial harm against themselves or other people, as demonstrated by recent acts of violence or overt threats of violence. Even though the analysis is the same as anybody who's not in the criminal system, it is still seen through the lens of the criminal case. And it's okay for forensic experts who are looking towards a person's dangerousness to society to look at the act that brought them in there in the first place. And so it can be very difficult to be discharged from the hospital after an NGRI is effectively utilized. So it's something that you want to talk to clients about, that even though they're not going to prison per se, they are going to be under lock and key for a period of time until the forensic expert and ultimately the judge that gets to make the decision decides that they don't meet criteria as a danger to society anymore. So it's not just about walking out of the courtroom, and why the insanity defense has to be talked about in depth with a client before they ultimately decide they want to take advantage of it. So that's it, the insanity defense in a nutshell. We'll see you next time.